Hello there, everyone. My name is Adam, and I'm back here with my dear friend Bill Henshaw. And here we are again with more updates on the case before it's not before the Supreme Court. It's been thrown out of there by the clerk. So I thought we'd get together again just to talk about this case. In my feeling, and I think Bill would have similar feeling about it. It is probably one of the most incredible cases ever to come before the Supreme Court. And I don't say that just because it's my case. It's because the issues that are presented in there are just astonishing. And it reveals without any question whatsoever that there is not one judicial constitutional court in California or in any lower federal court of the United States, and maybe not even the Supreme Court, given the way that they're behaving right now, or at least the clerk is. But as of this point, we have not gotten a response from either my petition for redress of grievance to Justice Thomas. If you'd like to see that, you can go to thespiritoflaw.com, and on the updates at the bottom, you can see the letter that I sent. And then Bill also sent a letter to Justice Alito, and you haven't received anything from him, right?
I haven't heard a word from that source yet either, since you mentioned it. If you have a letter, if you haven't put it up there, I'll send it to you to put up if it isn't on your website. But yeah, I did send one and asked you some very pointed questions about this whole business. So, by the way, have you heard anything back about the FOIA business with the oaths of office, especially of the justices of that court?
No. Actually, so that is a great question update. As soon as I sent out the petition, I got an email from a man named Paul Andrew Mitchell, and he sent me the fruits of his research, which was to serve a FOIA request on the United States to get the oaths of office and confirmation by the Senate. And there's four things I think that have to be in documentary form to confirm a federal judge. And he has done this for every single federal court in the United States, including the Supreme Court. And maybe I'll put that link on the homepage of my website to his page. But a majority of the justices do not have, they're missing some form of documentation or confirmation by the Senate, or some the confirmation that the president has to sign. I don't remember what it's exactly called, but it's unbelievable how many of them are actually missing. And so that prompted me to send a FOIA request to the DOJ. I did get a response from them, and they said that they were forwarding it to the Office of Information Privacy in the Department of Justice. And this was about 10 days ago now. And according to them, they have 20 days to respond. So we'll see. But I did ask for the oaths of office for every justice in the US Supreme Court. So as soon as I get that, obviously we'll do another video or something with an update on that. Yeah.
Okay, good. That's important, because if they don't have that oath to be bound by this Constitution, I don't think we're in a judicial court. And that's how they're getting away with it, because the Supreme Court, as you know, Adam, has said itself, Collins v. Virginia, it's treason to be in the court without jurisdiction or prevent one that has jurisdiction from exercising it. It can't be clearer.
Well, yes, it's clear to us, and sometimes it's clear to them, but it's so amazing. I mean, like, I don't know if anybody else has seen the other video that we did. If you haven't, the whole point of my case is that I got fined almost $1 million for allegedly not having a construction license. And the fine was exactly equal to the amount that my company got paid for doing the work. So basically, they say in California, if you don't have a license, you have to refund all the money that you got paid, and the customer gets to keep all the work, even if it's flawless. And there's no evidence of any damages, no offset for any of the benefits that you conferred. And they call it equitable disgorgement. Well, there's obviously nothing equitable about that, because anyone who knows what a court of equity is, it's based upon fundamental fairness and balance. And so in that situation, they would obviously give the unlicensed contractor offset for the benefits that were conferred. And if there's a fine or a penalty, obviously a court of equity cannot impose that. That's a law issue. But they said that I was in a court of equity and that this was quote unquote disgorgement. Well, it's not disgorgement. but what they did was a total penal forfeiture. So that's, I don't know what I got onto that subject for, but maybe you can remind me where we were starting with that. But that's what my case is about. Yeah. Do you remember where we were?
Not exactly, but it's okay. We can go on here. I've got a good half an hour or 40 minutes today, so we can catch up on things. But the whole thing, if you think about it, and you look at the 7th Amendment, which, as you know, doesn't apply to the states, but it secures the right to trial by jury in cases involving more than $20. And here you are. I mean, how do you justify that? By the way, if you're in the territory of California, that 7th Amendment does apply. And as you know, Article 2 of the Northwest Ordinance of 1787 applies to inhabitants of territories' right to trial by jury. Nowhere in sight.
Yeah, it definitely in a court of equity, you don't have a right to trial by jury. And obviously, I know where we were. We were talking about judicial constitutional courts. And so California was obviously admitted under the English common law. And there's, a lot of case history that shows that at the time California was admitted as a state, Roman civil law that was then enacted because this was a Spanish territory was repealed. Hang on one. Okay, sorry, we had to take a quick break. But yeah, the California was admitted as a common law state, and in common law, you can't, obviously, you have to have an action for damages in a remedial civil case. And obviously we weren't in a civil case because I was being prosecuted in a civil case for violation of a public regulatory penal law or penal statute, I should say. And that authority has been exclusively vested in the governor of California. Private people can't bring other prosecutorial actions upon other people. So that's another thing that deprived the court of subject matter jurisdiction in our case or in my case, and demonstrates that it's not a judicial constitutional court. It's anti-constitutional. So then as I went to the United States district courts, after having a void judgment in state court, they said, oh, well, we don't have subject matter jurisdiction to overrule a state court. And that's true if it were a judicial court and there were a valid judgment where the court had personal and subject matter jurisdiction. But obviously it didn't in this case. And so the federal district court refused to exercise jurisdiction to vacate the void judgment. And now there is no constitutional court anywhere in the state of California or the United States, because as you'll see, if you look at the procedural history on my website, I've been to all the courts and not one of them refuses to even recognize that they're finding me, let alone to vacate the void judgment that's against me. So now my house, they haven't started it yet, but just the beginning of this month, I cannot afford to pay the mortgage payment or the property taxes. And I'm already getting messages and calls from the so-called lender about not paying. And so, foreclosure proceedings are probably going to be here soon. And I've already been, reached out to a bankruptcy lawyer because I don't know bankruptcy law and, gotten that process started. So it's going to be very interesting, being forced into foreclosure and bankruptcy and all of this, of course, because as a result of the judgment, there's a statute, Business and Professions Code 7071.17, that says that if you have a judgment against you, your license is immediately suspended until you either pay the judgment or declare bankruptcy. So my license or my company's license, my ability to earn a living as a contractor has been suspended until I either pay this illegal fine or file bankruptcy. Those are my choices because there is no court that will recognize my rights. So this is why I was going back in the beginning to say that this is just such an incredibly profound case because it just demonstrates on so many different issues that there really isn't a court that you can go to anywhere in California or the United States and probably in many other states to get a remedy. And when I tried to go to the Supreme Court, the case was thrown out by the clerk for silly BS procedural rules that it didn't file some or didn't fit some format that it had to comply with the rules of court. So I'll leave it there. And Bill, if you want to comment.
Yeah, well, a couple of things, and we're still working on judicial courts, as you know, and we may have one in California, the California District Court. And I wonder if that's the behind the scenes reason why what happened with your petition happened, because, but it'd be nice, and I'm going to demand in my next letter to Roberts, they tell us openly, where are the judicial courts? If we're in a state, they have to be there. It's not optional. Article 110, no state shall pass any bill of attainder, taking of life, liberty, or property without judicial process. Has to be there. I think it's the California District Court. It may be the federal district court, and as you know, it may be the regular California court acting with concurrent circuit court jurisdiction, which in an earlier era, the Supreme Court properly ruled did, and in my view, does exist. And yet we can't seem to get into it anywhere today. An obvious problem. So we do have some work to do, in these types of areas, but I can't see how. And if California's down the state, the whole ballgame is over because none of the statutes will apply. Everyone that's an official actor there has been acting in the court they knew or should have known didn't have jurisdiction. There's that pesky Supreme Court again, acts of treason to the Constitution. And they knew or should have known. I mean, their lawyers went to law school, right? They got a sworn oath, right? They didn't know any of this. So we're going to have some affirmative defenses and maybe something in bankruptcy, as Adam and I have been discussing. That's an Article 3 court for people out there that don't know. And we may have some novel issues to present there, especially from the get-go. Who's bankrupt here? It's not Adam. It's the trust known as the United States under HJR 192 in 1933. That's the bankrupt, not us. So we get issues like that in there. And if that's the only forum we have, I can't see how we can be prevented from doing it. And maybe from there, reaching the U.S. Supreme Court and their original jurisdiction. And they knew better because when Adam did his petition, it's the best thing I've ever seen. All right, right on page 1, like I do, it says Article 1, Section 9, Clause 2, original writ. The clerk, even under Rule 1 of the Supreme Court rules, doesn't have any jurisdiction there. If those rules apply, just like the FRCP, that's appellate jurisdiction only, which they think is discretionary, quote unquote. I disagree with that from day one, but nevertheless, that's apparently the current thinking on the court at this time. So we'll see, because as Adam also knows, I've talked on my recent videos. So, by the way, When in Court on YouTube channel, and you can send me an email, youwhenincourt@gmail.com for information here. It's astounding when you begin to understand the truth of what's going on here, how bad it really is. But I still think we have chances, even this late in the game, especially with this COVID crap that they're trying to pull here. They're overreaching, and I think the justices of the Supreme Court know this. From what events that happened in the last term, we won't go into here. But I think enough of them are aware of it, that we're going to have a majority of the court, maybe as many as 7, who understand the issues when they get there, and should have with Adam's petition. If they had gotten this in their hands, I think the outcome would have been manifestly different. And in fact, it may have been summarily reversed what happened to him in this ridiculous case in the trial court. But the justices never saw it. Try to figure that one out. And they're the ones that said we have a right to present our case to the court of the nation, no matter how small the claims nor how little interest the community in its outcome. The framers of our Constitution thought it important in the interest of justice to provide a court superior to influence as possible in which that claim might be decided. Cohen's v. Virginia, 19 U.S. 264, and that's Chief Justice John Marshall, by the way, that infallible icon of Harvard and Yale, who was never wrong, right? And yet we can't even get documents filed in trial courts today. Clearly, they never saw Adam's petition because these things are so unjustifiable. I'm just so dazed at what the hell must have gone on there. And we're going to be after John Roberts for how he trained this clerk of court. We didn't tell him to make distinctions like this, especially when you see it on page 1. What's hard about this? There isn't anything. But they don't, and I don't know for sure, because I did, as Adam knows, when I was in that South Carolina jail cell 5 years ago, I hand printed, but that got there with no official action taken on it. but I'm convinced they got a call in Columbia that told them, get me the hell out of there because they don't want to answer the questions. Could be a similar situation here, and yet we have the right to do it and the need to do it in this day and age, most particularly. It's been 160 years now since the court, has done its job to say what the law is, and it'd be real nice if people here in Washington would start doing it again. Yeah, back to you, Adam.
Well, thank you so much for that very kind compliment. I forgot to say thank you as well for last time. That's so very kind. And I'm so grateful for all of the help you have given me, because holy moly, I don't think I would be where I'm at and have been able to present this case without your generosity and friendship and help in doing this. It's just, Bill's been at this for over 50 years, and his expertise and knowledge is one of a kind. And it's been truly, truly, truly an honor to learn from him and to have him as a mentor to help guide me through this process. Because for most any of us, and including me at many times, it can be incredibly overwhelming. There are just so many issues with things that have just gone so haywire and so upside down and backwards to the original intent of the Constitution that it's just mind-blowing to even know where to start. But on the issue you talked about, them not even getting the petition, that is the reason why I sent the letter to Thomas, the petition for redress of grievance, because I wanted the justices in the courts to have a copy of it, to see what the clerk did. And I have not heard back from Thomas at all. Now, that doesn't mean he's not doing anything with it. I don't know. I think almost 3 weeks now is quick enough to say, hey, look, we messed up. Send the petition in here, or don't even bother sending it. We'll file the one you sent us. We'll make some copies and distribute it to the other justices, and we'll get going. I mean, all the information's online. It's all there. So it's just fascinating that there's not been any action. But, the other side of that is it's almost like there's so many issues in there that are so profound and so, if you will, to upset this established quote unquote new world order and the fraud, deceit, and treason that they've perpetrated, that they almost can't even address it, because it's just going to open up Pandora's box to such a degree that, if the people aren't already starting to get an idea of what's really going on, would blow the roof off of it. And so, I don't know what's really going on, but, at least at this point in time, with the little bit of information I have, I'd like to hope that they're doing something, but, I don't know. I think all of us wants to have hope that they're going to do the right thing and follow their heart. But, at the same time, you and I both know that court has been instrumental in bringing the tyrannical overthrow of the United States into operation with their judgments. I mean, everything from making persons out of corporations to the legal tender cases to, well, I don't know, it's just all the 14th Amendment bullshit. They've been right there with the banksters. And the more that I read cases, I'm sure this is definitely truer for you, is I start to learn the history of what was going on at the time. Often you'll share that with me, and the court, as they admit, they'll take a case to decide an issue of the way that they want to shape the quote unquote public policy of the country, which is in almost every instance to line the pockets of the bankers and limit our rights, or to do something that is they have absolutely no power to do whatsoever. So yeah, I'll leave it there.
That reminds me when you just start talking about, corporations having rights and this, that, and the other. And I just did a video on this on my channel. It's not up yet, but it will be. We had some idiot judge, I think in Ohio somewhere. And for those of you who don't know, Ohio is what I call the league leader in not being a state admitted into this union, because they were supposedly admitted back in 1805, I think. But Congress never got around to admitting the state. And so it comes to sesquicentennial in the 1950s, the politicos in Ohio find this out, and they go to Congress and get Congress to pass an ex post facto law admitting Ohio from the original date, not in the 1950s like should have happened. And boy, if that's true, and think about that, if Ohio wasn't a state, that affects at least the administration of 8 different presidents. But it gets even funnier because this judge in Cleveland, I think it was, has just ruled, and I don't have the, anyone has the opinion, send it to me, just has ruled that hippopotamuses are persons and they have rights. I would love to see this opinion and how someone could reach a stage like that. In other words, animals have rights and we don't. I mean, how we're going to get that question to the Supreme Court, and we didn't know this at the time that Adam sent his petition in. We're going to be adding this and say, hey, wait just a minute here. Are you telling us that we're not only no better than animals, but we may be beneath animals, and we're the sovereign body politic of the nation and republic? I'd love to hear this one on the record. And this and Adam's case may actually gain a lot of attention in what I call the mindless mainstream media. And if that happens, as he suggested, Pandora's box, because we can prove there are no states and therefore no laws enacted, in our case, sack of tomato. There's no laws there. There is a null and void from the beginning, or the bills of attainder under Article 1, Section 10. And think about this too. Adam, as a sovereign citizen like I am, has an unlimited power to contract. We don't need the government's licenses to do a damn thing, especially a government in which we are not represented. That's a hell of an affirmative defense for all this license law, driver's license, marriage license, you name it. And now they're going after your kids. And this upcoming video I'll be doing on, the mandatory kids videos, especially going into school and this, that, and the other, because they think they own all of us and can just do this. And there's simply no factual foundation and legal basis for any of it. And I think they finally extended themselves too far in this area. I think we have a window here that we may be the first in line, Ab, now to get some real changes made. Because once that starts to happen, it's going to be impossible to stop. And people become aware of their rights and how good life should be compared to what it is now. And especially if we do have some slowdowns in the food supply chain, which I haven't seen enough relevant evidence yet about that. I'll be doing a report on it later. But if that happens, and now we have, mass outbreaks of violence and shooting with a lot of Americans having guns, it's not like Czechoslovakia in 1938. Now they declare overt martial law. Will that withstand a challenge with the 9/0 part if they do that? Wow, one does have to wonder. So here we are. Back to you, Adam.
Yeah, it that brings up for me the point that, realizing, well, I haven't shared this in any of the videos we've done so far, but I used to be a police officer here in Southern California. And, when I was a cop, people would say to me, do you have any idea how messed up the system is? And I say, like, I really don't. I don't have that experience. The people that I work with, they're good people. I mean, I had some issues with them that didn't have anything to do with, so to speak, law enforcement, but I trusted them. I never saw them lie or steal or cheat, and nobody was dragged into some back dark alley and beat up. I mean, I don't doubt that these things happen, but I never saw it. And it was pretty plain and simple. Most of my interactions when I was a policeman were, someone's calling 911 or they have a family disturbance, and it's pretty simple. If you're beating someone up or throwing beer bottles at other people or stealing someone's car, you go to jail, you get a timeout. That's how simple it was. It was pretty black and white, like the police car. So it was really astonishing to me to find out, going into court and being on the other side of the table, so to speak, just how egregiously corrupt it is, and how this policy has been in the state of California, so-called, for at least 30 years. But the 7031 law has been on the books since 1929. And even then, there wasn't a legislature that had a quorum to do any business, because it wasn't, commensurate with the number of representatives required to have a lawful quorum. So how the law ever got enacted, but that's when it began. And it basically refuses to recognize that the people have any inalienable right to their time and labor. And as a result of that, you have to get a license and pay a recurring fee for the privilege, the revocable privilege of doing construction work. And that is clearly antithetical to Article 1, Section 1, which is about having inalienable rights to life, liberty, and property and the pursuit of happiness. If you don't have a right to your time and labor, as Bill often says, then what the heck else do you have? And I'm not in this instance talking about, a state or an authority saying, hey, we found that asbestos is linked to lung cancer or other debilitating health illnesses, and don't put it in houses. That's fine. That's not what we're talking about here. This is a near $1 million fine and sending, financially destroying me and sending me into bankruptcy and foreclosure. It's just insane that they refuse to even recognize the penal nature of this, and that there's not, in my experience so far, one court anywhere in the nation that is even doing its job or willing to tell the truth about all of this. And so, after I had a lot of those experiences with the courts and them refusing to listen, I'm wondering, hey, is this because I don't have an attorney? Is that the only person they're listening to these days? And I tried calling around to find an attorney, and they couldn't even understand what the issues that I was sharing. I went round and around with 3 and 4 of them, and they could not understand that this was a penal statute and that the court didn't have jurisdiction for a private party to prosecute another private party. And none of them absolutely want anything to do with taking on a judge, because they believe it's career suicide. And I think a lot of that is exactly brought us to the situation that we're in, is that, when they do an appeal, they say, oh, the court erred. The court made an error. And it's not, no, the judge had no authority to do what he did. And as a result, he has civil liability for damages. They don't even want to go anywhere there because, as I was saying, they believe it's career suicide. And I have a couple, close friends that are lawyers, and it's been mind-blowing to hear and see their reactions to some of this stuff. And so, yeah, it's going to be interesting to see what happens next. I think I will file a petition for redress of grievance, or in other words, change the name of the petition that I filed and send it right to Roberts, care of the United States, and do a petition for redress of grievance pursuant to the First Amendment, and see what happens there. And then maybe Michelle Steele will get a copy, and maybe Joe Biden as well. But at this point, anything they do is going to be admitting what has gone on so far. And I think that that's what's going on, is they're terrified to admit the truth about all of this. But the truth is what's going to lead us out of the situations that we're having in so many other places in government, and with all of these mandates and the tyranny going on, is, the truth is at the heart of all of this stuff. So I did make complaints to the California legislature and the Orange County Sheriff's Department and the Santa Ana Police Department. And while the Sheriff's Department did take an information report, they concluded that there was no criminal activity to be discovered and closed my case. And the Santa Ana Police Department refused to even take a report and investigate. Now, fine, if you want to make a finding that you can't find any criminal activity, I don't see how you get that, because forcefully taking property from another, this is basic robbery in the police academy, the forcible taking of property without lawful authority at 211 of the Penal Code. How do you not get intent? They know what their duties are. They know what the constitutional protections are that they're supposed to apply. It's pretty simple, as you often say, Bill, but even if they couldn't find any criminal activity, they still have a duty to take a report and investigate it. And they can't just slough off your rights because they just decide they don't want to do anything about it, or they don't find criminal activity. If your rights are being violated, that is the core essence of the whole point that people join a political society, is for the so-called protection. Well, the protection that it seems that we need is from, quote unquote, them. And this absolute just, hideous crap that they're doing. So, I don't know what's next. We're going to see. Bankruptcy may be coming up. They've all been put on notice of all this. So all the damages that are accruing every day as a result of this, and if I have to go file bankruptcy, if my mom loses the house as a result of it, it's just it's so sad is really what I feel about it. It's sad that this is the state that our country is in. And the other part that I wanted to bring up is that I've gotten quite a few messages from people. I can't even understand what you've written on page 1, Adam. I feel like I need to go back to college just to get a degree and just to read some of the terms that you're using on even the cover page of your petition. And that's another sad thing, is that in the United States, in California, whoever's at the helm of the education system has just removed all of the necessary things that for us to understand the history and the Constitution and the laws of the United States and California. And so, now I put out a petition like this and nobody knows what it means. And frankly, despite going to the police academy, I didn't know what a lot of this stuff meant. But what it's taken is the last, 4 years or so of my life studying nonstop almost every day to just get a handle on it, and reviewing the research materials and things that Bill has shared with me, and going back and forth with emails and other phone conversations almost on a every other day basis. It's just been it's been overwhelming, but that's what's allowed me the opportunity to be able to write in the way that I do and speak about it. Okay, back to you, Bill.
Okay, well, a couple of thoughts about this, and people that don't know, and I didn't have a clue either, and Adam didn't. He didn't teach us a damn thing in school about any of this. And for just a quickie on that, for example, all I ever heard about Andrew Johnson was he was the first president that was impeached. They didn't tell you why, didn't tell you what for. He survived it by one vote, and what he did was to fire or try to fire Edward M. Stanton, the then Secretary of War, which he had every right to do. But the big deal about that is, if I would have seen one of his vetoes, for example, the Reconstruction Act of 1867 in 11th grade, my life would not only have been strikingly different, I was right outside of Washington, D.C. at the time. They don't want you to know any of this. And then what you find out is that, with this case that Adam's been involved in, and almost all cases, that the U.S. Supreme Court has apparently ruled that there is no right to an appeal in any criminal case. And that certainly has to apply on the quote unquote civil side, although I think what we have here with Adam is quasi-criminal in nature, to which there would have been a right to effective assistance of counsel in a jurisdiction foreign to our Constitution and unacknowledged by our laws, and in a case where they couldn't prove there had been a voluntary, knowing, and intelligent waiver of any rights. That would have been a hell of a lot more like it, but this is what you find out. An appeal is a creature of the Roman civil law. For those of you who don't know, the common law remedy on the appellate level will be a writ of error. And those apparently are not available even in the U.S. Supreme Court either. They got done away with in 1928, I think, the Judiciary Act there, or supposedly done away with. But that's the kind of crap you have to deal with. And then in California, Article 6, Section 13 of the Constitution, they think is currently in effect. It virtually directs all the appellate judges to find all errors and omissions in the trial court to be harmless errors. What's the problem? You don't have any rights. Why are you here? They're never that open about that in their opinions, but you get a summary denial of the appeal, and that supposedly ends the matter. And that's why we have to have remedies like this non-federal habeas corpus that state courts should be able to exercise. They have that power with the concurrent judicial power of the state of California and the United States. That's the way it was originally, and I think it still is. But we're talking more about that later. But there simply has to be remedies here, ideally trial by jury according to the courts of the common law, because a case like Adam has never gets to a jury. Because we can prove, that all that went on here was done by corporations that do not themselves have any standing in a judicial court. And pay attention to this one, people, because what you find out is, and this is true across the country, all these corporate entities have registered at all in Sacramento are with the Territorial Secretary of State. We are domiciled in a state judicial district. They can't come into our jurisdiction and they can't compel you into theirs. That had I known Adam at the start of all these proceedings a long time ago, would have been put in right away and saying, what the hell is the problem? You know, where's the prosecuting party? There isn't one. And in common law, there has to be substance on both sides of the agreement. That's not there either. I mean, there's affirmative defenses that would have been recognized in an earlier era in California. They just aren't today. And I had to laugh, by the way, when you said that BP section goes back to 1929. And I mentally said to myself, boy, the state bar didn't waste any time, did it? Because those of you who don't know, the state bar statutes came into existence in 1928. It didn't take them long. So this is the kind of crap that we have to deal with and get around. And I realize the magnitude of the issues, but from where Adam and I sit, that's not our problem. You know, these supposedly neutral magistrates at the U.S. Supreme Court, again, Toomey v. Ohio, that are supposed to be neutral, and when they get issues like this in front of them, especially unopposed, and Adam hasn't been opposed, I've never been opposed. Not only do they not know how to do it, if they attempt to do it, it will convict them on the record of treason. You can see the problem, but it isn't our problem, is it? And this is how these courts, you know, somehow think they work. And the wheels of justice spin forward inevitably. And this is what happens. So we're trying to, if we avert it here, by the way, this is going to be a big one. It's going to get a lot of attention in the mainstream media. And it will set the stage for a lot of other people out there that are situated like Adam and or myself that have similar cases, whether student loans, mortgages, you know, whatever. You know, now we're going to have a precedent that we can rely on and probably will prevent cases like this from even being filed, let alone having to have any opposition. But if you have to have a, you know, assistance of counsel, and by the way, here's another thing, people, you walk into their system, especially in the traffic courts or the criminal courts, there's a presumption of incompetence against you from the moment you're there. And the judge tries everything in his power to appoint counsel for you in order that you get a quote unquote fair trial, otherwise known to the Constitution as a directed verdict of guilt. And that's all you get, because that's all these attorneys know, and they're all of them in on the ballgame. They're all of them are unregistered foreign agents. They all need to be appointed by the president if they're in territories. None of them has been, and they couldn't care less about the outcome of your case. Only extremely rare cases does that happen. I think the public defender's losing percentage is about 96%, which should tell you all you need to know about that. But here we are, and you don't have a chance from day one in their courts. So obviously the question is getting out of their courts, and I'm still convinced there are ways to do that, particularly with the California District Court. I'll be updating on my videos about how that's going on, because I'm communicating now with the local county clerks here. They're the ex officio clerk of that court. Has nothing to do in California with the Superior Court, which is across the street from where the recorder is. And none of the judges in there are competent to be a district judge. This is where the real relief comes. I'm convinced of it. If we have it at all, it must be there. And from there, if we were to seek review from the Supreme Court, I think in all probability we would get it, because that's now a judicial court. There are judicial issues, Article 3 issues, you know, cases and controversies, and that's what it is that they know they have to decide, not anything coming out of the BS legislative territorial tribunals. And that's the other big question here. If we can prove that you're in a legislative tribunal, and we can, how did that happen? We would love to know the answer to that question. If we're not a state and they're trying to make you, you know, responsible for laws from a government in which we're not represented, not to mention, as Adam said, the ratio of representation. And believe it or not, for the House of Representatives, read Article 1, Section 2. And, you know, my bad, when I was in school, if I'd have read the whole Constitution like I should have done, I would have been better off, but they never discussed any of this stuff. 1, 2, maximum relation of inhabitants to representatives, 30,000 to 1. What do we have in Congress? 438 with 325 million people. You ready for this, people? What do we need in Congress? 11,200. And I figure they could rent out, Tiananmen Square, in Beijing, or go over and rent out Red Square in Moscow. They need to see the legislature of that size to have all the members there. And it isn't just the numbers, because when you have that many people, the districts are much smaller. People like you, I, and Adam can run for office if we're inclined to do it. People that really understand the law and what it means and represent people in these legislative assemblies, and not be subject to the two-party system, the Demo-Republican system, where if you don't play ball, they withdraw all your funding and you don't even run for the next election, let alone win it. There's a lot to be said for all of this. And you can find out in the Federalist Papers, I believe it's number 55 by James Madison, thank goodness, not Hamilton in this case. It may be 52, but he does talk about this issue and recognizes the importance of it. And yet they don't have anything like that. And there's zero in the Senate. We'll go into that in another video, but trust me, zero qualified members in the Senate. So they got some real trouble here. It just, and you start raising these issues from day one, especially in the criminal setting. But hell, Adam, you've been in the quasi-criminal setting, and these issues arise there just as surely as they would anywhere else. There's simply no authority there. And that's the cognitive dissonance that we have to get around sooner or later. And that's why, by the way, in my South Carolina case, where I sat there 7 months as a political prisoner, and I stopped them cold in the first 30 seconds of the first hearing I had, and I was laughing at them from day one. And when you have the power that we have, you'll learn you can do the same thing. They couldn't do anything with me, and they wanted to, but they knew they couldn't go to trial because I was real confident, and I wouldn't have been shackled by a state bar attorney in front of a jury. That's a disaster in any setting for them. It really is. So that said, that's what they want to do. But think about this. You walk into their court, you're incompetent right from day one. How in the world, for example, do you regain confidence to form the criminal intent to commit the crime, or in Adam's case, violate an allegedly applicable penal statute, not to mention regain competence on election day? Which way is it and why? I love to hear somebody on the quote unquote state level answering that question. And John Roberts, look out, it's on the way to your headquarters too. We're going to want to know how at one and the same time that can possibly be true, competent or not. Which way is it? And that's saying, in effect, what is the relationship between the sovereign body politic of the nation and republic to the government? Is it principal and agent, which would be immediately recognized by the framers? Or today, is it now guardian and ward, more accurately described as master and slave? For those who be out there and believe in civil rights, you can see we haven't come anywhere at all in the last 150 years. 14th Amendment was a mirage. It wasn't what it put there to do. So if it's master and slave, my goodness, let's get it over with, have the Supreme Court go out of business, say no judicial courts, and let the legislatures do what they're going to do. Simple, right? I ramble on a bit, Adam. Go ahead, your turn.
Oh, you're great. You're great. But that's where we're at. I mean, that's essentially what they're saying. They're not, I don't know. We'll see what they do with my case or what ends up happening. But there was just two things that came to mind while listening to you talk. And the first one was quasi-criminal. And I just wanted to ask you a question about why the quasi part.
Well, technically, it's not like you went out and murdered somebody, shot somebody down on the street with a gun and killed them, which would be clearly a criminal act. This is quasi, and of course, they weren't threatening to throw you in jail, at least for the most part of the proceedings that you've been in. So I would say, quote unquote, quasi-criminal, but for these purposes, and especially if it's in commercial law, which is admiralty and maritime, they have a heavy burden of proof on jurisdiction. As you know, the Supreme Court has said that. One of the cases is Steve v. Maine. Send me an email, uwinnincourt@gmail.com. I'll tell you all about all these kind of subjects. But they have a strong burden of proof, especially so with a corporate entity taking the place of, in effect, the state attorney general, who's the one that should have been prosecuting here from day one. How in the Lord did they get delegated this authority? Number one. Number two, it raises some obvious separation of powers questions here, which in states, in theory, can't arise because those three departments of government are separate, right? Not anymore. Oh, by the way, a case I meant to mention earlier on this subject, you'll learn all about this one in my pleadings that I have, and I gave it to Adam too, called State v. Hopkins out of Oregon in the late 1950s, where this Oregon judge put in a petition for an original writ to the Oregon Supreme Court and got it granted. And he was wondering how come he was losing his job when he was still a judge of the local county court there. I think it was Multnomah County, but the county court. And the Oregon Supreme Court said without 2 seconds hesitation, no problem, because all that happened here was the Oregon legislature simply exercised the power it had to do away with this Multnomah County court and, keep it there in name only. So the people that walked in there think they're in a judicial court, but all the judge is now exercising is administrative authority. And I think that was the spur for California to do the same thing in 1966 when they had that mass amendment of the Constitution, like what happened, Adam, and they took out the reference to any judicial power of the state of California. I think that case in Oregon may have given them strong encouragement to do that, given the time frame in which it occurred. So they look like courts, smell like courts, taste like courts. They're not. And that's where the oath of office comes into play and some other jurisdictional things we can do to establish it. And unless Article 1, Section 9 and or 10 of the Constitution has been repealed, and I can't find that anywhere in my version of it, then all the laws they think apply are bills of attainder, even if everything else is perfectly in order. They can't possibly apply to us. If they want to use them against corporate entities, they can do it. The government creates corporations. They own them. They're saying they created us too. I would love to see the factual foundation and legal basis for that one. So that's it. Back to you.
So I just wanted to read this to you because this is very, very fascinating in regarding to the quasi-criminal thing. So as you're well aware, in California, we have the penal code, not the criminal code. But this is what the definition of a crime or public offense is in the penal code. It says a crime or public offense is an act committed or omitted in violation of a law forbidding or commanding it, and to which is annexed upon conviction either of the following punishments: death, imprisonment, fine, removal from office, or disqualification to hold and enjoy any office of honor, trust, or profit in this state. So basically, any regulatory law, including the vehicle code, you get a fine. It's you're committing a public offense in violation of a law forbidding or commanding you to do something, and you get a fine. Penal code, it's a penal action. And same thing here. And that's why the prosecution has to be completely done by the state. So in my perception right now, I don't even think it's quasi-criminal. I think whatever the case is, maybe we could call it quasi-criminal, but it still had to be a prosecution brought by the state on behalf of the people and not by private parties. The other thing I wanted to bring up was you were talking about legislative tribunals, and I just wanted to read you something that the court said in my case at trial. And what he's talking about in this context is he's about ready to fine me nearly $1 million. And so this is his justification. This is what he says. The Supreme Court of California, I've added some words here, has found that the contractor's license law is draconian in its effect, but that's the intent of the legislature. The legislature expects contractors to be licensed at all times during the performance of work on a project, and in failing to do so, be licensed at any point in time, subject to the forfeiture. In other words, this is what the legislature has said, and apparently he doesn't think he has any power to apply any of the protections of the Article 1, Section 17, or the quote unquote 8th Amendment, none of it. And it's just, as I read that, it's just astonishing that their refusal to even recognize. He says it's a forfeiture. Well, there's two forfeitures, either one in personam or one, what's the other one? In rem.
In rem, yeah.
And clearly this was in personam, unless they think I'm a corporation, obviously, then you could say that it's in rem, which they do. So yeah, it's just, that's just more to me evidence of what you're talking about the legislative tribunal, is that these aren't independent judicial constitutional courts. They're just administrative tribunals that are just going along with rubber stamping whatever the legislature says. So if the facts meet the offense, that's the case. And other evidence of it is obviously in my petition on the spiritoflaw.com that I submitted to the Supreme Court, which is that statutory courts had no common law general jurisdiction at all, no common law or equity jurisdiction. They only had the jurisdiction that was supplied by the statute, which is where in the hell they're getting that. Because if you read the California Constitution right now, there is no jurisdiction setting power of the legislature. In other words, the legislature cannot confer or cannot extend jurisdiction to any statutory proceeding in any case in California, because that is not in the Constitution. It was removed, I believe, in 1966. And so if anybody watching this wants to know a little bit more about what I'm talking about, there's a whole section in the petition about this. But just go to Article 6 of the California Constitution of 1879. That's currently online under California Legislative Information. And you'll see that there is no Section 5 conferring any law or equity jurisdiction on any court in California. So not only is there no statutory jurisdiction, there's no common law or equity jurisdiction at all. So they're operating on a jurisdiction called all other causes, which is totally unknown to the history of California and to the Constitution for the United States. There's no such thing as all other causes. So where they're getting this authority, who knows? But all of it vanished well, at least going back to the so-called ratification of the Constitution of 1879. And later, if we even assume that that was valid, to the amendment that happened in 1966, which you can all read about in my petition. But the other thing to bring up is just that, I don't know, a lot of the feedback I've gotten seems to be that people just can't even stomach reading what it is what's in my petition and the things that we're talking about, which is astonishing. And I get it, because there was a lot of terror that was running through my veins when I first began to study all of this. And I, as many others have said, you have to process this in your body as you work through it, because it is a complete opposite. I mean, the best word for it is a betrayal of everything that we've been taught about law and history in the United States. And as you just even begin to pull on a thread of this whole thing that they've presented of there being actual real courts and real issues that are addressed, and you find out that there's anything but that. So back to you, Bill.
Okay, well, a couple of things here that we can talk about it with the legislature again. I talked about the Congress and all that. In California, where we are, what do we have here? 40 million odd people the last time they counted the population. We have 80 in the California Assembly. Do the math. That's a ratio of 500,000 to 1. With senators, 40. That's 1,000,000 to 1. That's nowhere close, to being, even if they were qualified to hold those seats, and none of them are. That's not even close. Again, we need to have much smaller districts. More people can run, more independent people to get in there and have their voices heard when these laws are being proposed, let alone enacted. And things would be a whole lot better, if we had that. But the good news for us in California, and I checked several other quote unquote states, and it's very similar, the voter registration form, you have to declare under penalty of perjury that you're a United States citizen, parenthetically, as that term is described in Section 1 of the 14th Amendment, which we can prove not only doesn't exist, it never has existed. So therefore, the electorate doesn't exist. Where does their power come from? And here's those magical 4 words: consent of the governed. It's not there. I mean, wow, it's just as simple as that. And you go back, but as Adam said, we got admitted into this union on September 9th, 1850 as a common law state. Fortunately, in an earlier time, I was able to download a thing called the Report on the Civil and Common Law, 1 Cal Reports 588. And I've got copies of it now. And they talk a lot about, what we were going to do because it was a civil law state. We got it from Mexico, so they were under the French civil law. And you read the report on civil and common law, it's clear as day by the San Francisco Bar Association, long before the state bar ever existed, thank goodness. So that happens. And nowadays, you look at the recent versions of the California reports, especially the ones printed in Beijing, China. And let me know if you can find these pages anywhere in volume 1. It's been conveniently omitted. They don't want you to know it was admitted as a common law state because that's anything but what we are now. And the problem they have is they can't show any valid factual foundation or legal basis for the change. All they have is the 14th Amendment. And if they want to take me on that one, especially in front of an inflamed jury, come get me. It isn't going to work even in their corrupt courts. It's that simple. So that's where we have to get here. And maybe in Adam's case and the work I'm doing behind the scenes and with my other cases that I have going on here, we're finally going to break through, even with these Supreme Court justices. And one wonders, by the way, if in fact they are a group of political hacks, as was suggested by Amy Coney Barrett, who was upset at that suggestion. But if they haven't got oaths of office, and if the president's office is vacant and Congress is vacant, how could they have been appointed to their seats and confirmed by the Senate? Another question they're going to be getting from both of us. Show us your bona fides, sir. If you are the U.S. Supreme Court, then you know and we know what your duty is. Marbury v. Madison. Say what the law is. If you're not going to do that, then tell the American people, we'll take it from there. Back to you, Ed.
Well, getting close to concluding, I think that's exactly what they are telling us by just this tacitly omitting that there is no constitution and that they're going to refuse to do their job. I mean, how much clearer can it get than you send a petition to a justice of the Supreme Court for redress of grievance to file this case and you hear nothing? Crickets. I mean, this is something that you and I have been talking about for quite some time. I've been sharing it with you. It's just, this is not like I use the example of if I had done something to harm you, or you had done something to harm me, and I notified you of that. I mean, you would be on the phone within 30 seconds. Oh my gosh, I'm so sorry. What can I do to fix this? You would create a remedy immediately to fix the problem and make sure that I was okay. And this is not what happens here. They don't seem to want anything to do with telling the truth and fixing the problem and making things right. Now, I don't know that that's true here. It can change at any moment, but so far, this is what I have experienced from the courts in California and the United States, and now at least the Supreme Court. And this is the last thing that I ever would have suspected coming from Thomas. But, I don't know. I really do not know what is going on behind the scenes there. And I hope that they are, finding it in their heart to do the right thing, but we'll have to see. We'll have to see what happens. But I think they're, overtly saying get lost by the fact that, there hasn't been an invitation to refile it, or they haven't filed it on their own. No response in about 3 weeks now to the letter that I sent. I mean, here we are.
Yeah, I know, me too. And as I say, I think it wasn't just those two with that California case. I think the 3 Trump appointees are on our side here, at least, if not Roberts and maybe Breyer. I think we may have an active majority of the court now ready to act. I don't know what's going on behind the scenes, especially with the court packing plan. which we'll see how that plays out if it happens at all. So we just have to, at the moment, take a wait and see and keep filing papers and keep doing our job here and keep after them. Because I think the good news is for you and I, Adam, that if they are going to do their jobs, we're going to be ones of the first in line when that happens. Because we're there and we know what's going on, and we know, we have the right to be there, and we know why we have the rights to be there. And that's what people need to learn. So remember about that, by the way. Send me an email. You went in court at gmail.com. You'll be stunned what you learn here. I certainly was when I went through all those years in UC Berkeley and Hastings College back before where we had internet. It makes it a lot easier. There's still things that you need to do, and even in the law library, but it's so much easier than when I started out. God, I'll be 39 years next year, 5 decades, 39 years. I can't believe I'm saying that, but better late than never. And in fact, I joke about it sometimes, and I say, well, I think I'm a refugee, and I may well be a refugee from March 5th, 1857. I fit much more comfy in that 19th century than I ever do in the 21st. And, Google that date, you'll see exactly why I said what I said there. I know the exact date. I don't know how I got here. May have to ask Bill Gates and Elon Musk about that one. But here I am, for what that may be worth. And with a little luck and family genes, another 8 or 10 years to keep raising as much of a ruckus as I can here and help others to do the same thing and get these people to get it right. God, it really isn't hard once you, my goodness. Weird. Okay, back to you for a closer, Adam.
Well, with that, I just thank you for making time again to share, and we'll see what happens next. We'll do a video update on the FOIA request that I get back, which should be in just a couple of days, and take it from there.
Yeah, we could do that, and you just check in with me. We'll schedule something in. My schedule's gotten a little screwy of late with now, by the way, people, if you don't know, I've been drafted into a really scary situation as a babysitter for a 5-year-old. That's much worse than going for one of these back road bastards, I can tell you that. But I'm going to try to have a lot of fun with it. But that said, we'll work out the schedule. We'll be doing another video or 2 here before this is all over, and I'll be doing some of my own on my YouTube channel discussing issues like this, and see if we can figure out a way to get this job done and get ourselves on the road to recovery here, back to the nation and republic of defined and limited values. That would be so much nicer to see. It wouldn't be perfect, but starting from that point, we can make it a lot better for all of us and our children and our posterity. That's why I do what I do, and I know it's why you do what you do too. It's a long-term interest, and that's why they can't beat us in front of a jury. There will be a lot of money if and when we ever get there, but that's not why we're there. We want to make differences. The jury is going to recognize it and respond to it. They won't be so lucky on the other side. I'm just waiting for that day to come down the pike. So that said, thanks. I will see you the next time we do one.